Ready? Exercise number 4, Series B, Legal Matter. Start. These writ petitions under Article 32 of the Constitution of India seek a declaration that Section 12, Subsection 2, Subclause C of the Maharashtra Jila Parishads and Panchayat Samitis Act 1961 is ultra-virus. The provisions of Articles 243D and 243T, including Articles 14 and 16 of the Constitution of India. In addition, the validity of the notifications dated 27/7/2018 and 14/2/2020 issued by the State Election Commission, Maharashtra, providing for reservation exceeding 50% in respect of Jila Parishads and Panchayat Samitis of districts Wasim, Akola, Nagpur and Bandra have been questioned, and it is prayed that the same be quashed and set aside. Stop. Next para. The conundrum in these matters revolves around the exposition of the Constitution bench of this court in K. Krishna Murthy under bracket Dr. bracket out and others versus Union of India and another. Relying on the dictum in the said decision, the petitioners would urge that it is no more open to the respondents to reserve more than 50% under bracket aggregate bracket out seats in the concerned local bodies by providing reservation for scheduled castes / scheduled tribes and other backward classes. Whereas the respondent state would urge that the stated decision recognizes that it is permissible to reserve seats for OBCs to the extent permissible in the 1961 Act. Further, in exceptional situation, the reservation for SCs/STs/OBCs in the concerned local bodies under bracket Jila Parishads and Panchayat Samitis bracket out could exceed even 50% of the total seats. This is the central issue to be dealt with in the present writ petitions. The provision in the form of Section 12 of the 1961 Act enables the respondents to reserve 27% of seats in the concerned Jila Parishads and Panchayat Samitis. Stop. Next para. The provision in the form of Section 12 subsection 2 subclause C can be saved by reading it down to mean that reservation in favor of OBCs in the concerned local bodies may be notified to the extent that it does not exceed 50% of the total seats reserved in favor of SCs/STs/OBCs taken together. On such interpretation, Section 12 subsection 2 subclause C can be saved, and at the same time the law declared by the Constitution bench of this court can be effectuated in its letter and spirit. Stop. Next para. This bench observed that the following triple test/conditions are required to be complied by the state before reserving seats in the local bodies for OBCs. Quote. Next para. To set up a dedicated commission to conduct a contemporaneous, rigorous empirical inquiry into the nature and implications of the backwardness qua local bodies within the state, to specify the proportion of reservation required to be provisioned local body wise in light of recommendations of the commission so as not to fall of overbreadth, and in any case such reservation shall not exceed aggregate of 50% of the total seats. reserved in favor of SCs/STs/OBCs taken together. In a given local body, the space for providing such reservation in favor of OBCs may be available at the time of issuing election program under bracket notifications bracket out. However, that could be notified only upon fulfilling the aforementioned preconditions. Admittedly, the first step of establishing dedicated commission to undertake rigorous empirical inquiry itself remains a mirage. To put it differently, it will not be open to respondents to justify the reservation for OBCs without fulfilling the triple test referred to above. Full stop. Thank you very much.